Okay, good afternoon everyone. I'd like to present today a case study of the application of impact assessment to a specific policy issue within the road transport area. And in doing so, I think draw out two lessons that are almost contradict each other. The first is that even given substantial data problems, applying impact assessment can provide policymakers with very important inputs to decision making. But the second is that if impact assessment isn't applied as part of an integrated system and in a timely fashion, then it's very unlikely to have any significant impact on policy outcomes. So what's our case study? It's called the Road Safety Remuneration System. There was an act called the Road Safety Remuneration Act, and I'll explain about it as we go through. The origins of this system, there's a body called the National Transport Commission, which some of you may be aware of. It's a research and policy making body shared between state and federal governments, which also is responsible for developing model regulation. And it commissioned a paper back in 2008 to look at the issue of possible linkage between rates of pay for truck drivers and their safety performance. And the resulting paper argued that there was a severe crisis in the road freight industry. It said that, in fact, there'd been no change in the number of fatalities involving articulated trucks for 15 years, when the context was one in which, of course, the general road toll had fallen quite substantially over the same period. Interestingly, it did concede that more detailed investigation into the causes of heavy vehicle crashes was needed, but nonetheless it recommended that a national scheme be set up which would set mandatory rates to cover both employee drivers and independent contractor drivers in the industry. So having received this, the National Transport Commission endorsed its findings and put it forward to government. And government responded by publishing a discussion paper in 2010, which proposed legislation along the lines that had been recommended. That legislation was duly passed, and it came into effect in the middle of 2012. It established a quasi-judicial tribunal which had price-setting powers for the industry. It could set minimum freight rates for those independent contractors, and it could set wages and conditions for employee truck drivers, which was an interesting decision because it effectively duplicated an award wage system that was already in place and which already covered truck drivers. Interestingly, it was also empowered to set a number of other safety-related rules. So its remit wasn't confined just to remuneration. Now, a little more than a year after that legislation came into effect, a new government was elected, and that government had a pretty strong red tape reduction focus. And it came into government with a specific policy commitment to review this Road Safety Remuneration Act. And I was appointed by the new minister to conduct that report and provided him with a report in early 2014, so still less than 2 years after that legislation had come into effect. And that was obviously important in terms of what was able to be done in terms of a review. Now, we know impact analysis is a tool to promote evidence-based policy making, and the OECD certainly argues that it should be applied to existing as well as proposed legislation. And as someone who's been an impact assessment specialist for a long time, it was obvious that I was always going to adopt that frame of reference in undertaking that rule. So what I want to do is go through each of those key elements of an impact analysis and indicate how the review applied them in practice and what the results of that was. So the first one was establishing what was the nature of the problem that was being addressed here and what was its extent. Was there indeed a severe crisis in the industry? Was it true that fatalities performance had not improved in absolute terms for 15 years? How could we find out? Well, we decided we needed to analyse fatality and accident statistics both in a time series sense and also in cross-sectional terms, looking at comparisons of Australia and other countries. Now, you can do a snapshot and look at the number of fatalities in 1992 and in 2007 and find that they're the same, and that might be seen to provide a bit of support for what was set out in this paper that the NTC published. But if you actually plot it all as a graph it looks like the one on the left there. So that begins in 1990. Everything's scaled to 100% is the 1990 figure, and so we see the relative level of improvement in fatality performance, orange line being articulated trucks, fatalities involving articulated trucks, and the red line being the road fleet as a whole. And as you can see, there's a clear declining trend for both of those, and the extent of that decline is round about the same. It's sort of sensitive to the start and end points. I've included the graph on the right as a matter of interest because that contains all of the data that would have been available to the author of that report commissioned by the NTC. We only started collecting that data on articulated truck related safety performance in 1986. 2007 would have been the latest available data at the time that that report was completed. As you can see, the conclusion is very much the same over that period. So we found that in raw fatality number terms, the reduction was about the same over a period of nearly a quarter of a century now for articulated trucks as for the vehicle fleet as a whole. When we actually then looked at growth in the road freight task over the period and compared that with the overall growth in vehicle kilometres travelled, we found that in fact the performance in the heavy vehicle sector was a bit better than it was for the road fleet as a whole. We did similar sort of analysis based on rigid truck related fatalities. There's less data there, but there is some, and on accident involvement rates, and they all told a pretty similar story. So then we looked at the cross-sectional data. How did Australia compare internationally? And I'm indebted here to the ITF, and particularly that 2011 report of its moving freight with better trucks. This table is taken from there. It shows fatality rates, fatalities per 100 million vehicle kilometres for 9 different countries. If you look at 2005, which is the most recent year that there is data there for all 9 of them, Australia ranked 3rd best out of the 9th. And we also identified some other earlier material which looked at this sort of international data and concluded that the key shortcomings in Australian terms in terms of that safety performance were that we lacked divided roads and limited access roads for heavy vehicles, and that was essentially the explanator of the difference between actual Australian performance and that of the sort of best practice in the area at the time. So the data showed that the extent of the problem didn't appear to be as had been claimed in the key documents that underpinned this legislation. Clearly there was no severe crisis that could be identified in the way that it had been proposed in that paper. The existing approaches were obviously quite effective in terms of leading to sustained improvements in safety performance. But what about the nature of the problem? Is it possible to say that low remuneration rates are leading to a situation where safety performance is poorer than it would otherwise be? So we sought to answer that question in a few different ways. We looked at the research literature on that question, such as it was. We researched international practice, asking the question, well, what are other countries doing? Are they, in policy terms, addressing remuneration as a safety issue? And if so, what's the experience? And we also asked the question, well, are truck driver remuneration levels in Australia low? To start with the research literature, it actually looks at quite a number of different relationships, maybe driver income versus accidents in some cases. In other cases, it's company income rather than driver income that's looked at. In some cases, it's unsafe behaviours, speeding and driving for longer than regulated hours and so forth, rather than actual accident involvement. We focus particularly on driver income and accident rates for a couple of reasons. One being that the Act itself was all about driver income, and secondly, obviously, actual safety performance seems a more compelling metric than precursors, unsafe behaviours, if you like. We found, confining ourselves to those relationships, actually very few relevant studies, and the 3 main ones are listed there. They all find statistically significant links between low remuneration and poorer safety performance. But when you look closely, what they actually find in terms of its policy significance, is quite different. So Belzer finds that there's actually a very strong relationship between the two variables and that it's linear over a broad range. Rodriguez went back a few years later, was part of the original group with Belzer that produced that earlier paper, and reinterpreted the same data set and concluded that there was actually a U-shaped function, such that remuneration that was too low was associated with poorer safety performance, but so was remuneration that was too high. Interestingly, there's no theoretical discussion in that paper as to why that might be. Nafuko found a statistically significant link, but in this case it was a very weak one in the sense that it explained very little of the variation in safety performance. So as you can see, you'd have very different policy conclusions from those three different papers. The American regulator, the Federal Motor Carrier Safety Administration, had a few years earlier looked at this issue and had warned that the specific nature of the linkages was very much open to question given the state of the literature. And one obvious question is, well, if we do see that companies that are paying higher wages seeing better safety performance, is it the case that a particular cohort of drivers is driving more safely because they're better paid? Or is it just that that company is able to recruit better drivers because it's paying higher wages? So we concluded that given that there was a paucity of studies and that there were widely differing conclusions, that this was actually quite a weak evidence base. And it was obviously pretty uncertain what your appropriate policy conclusion would be. It's important to look at the history of this as well. First in the US and subsequently in Europe, there was deregulation, or removal of the economic regulation, I should say, of the road freight industry in the early 80s, or starting in the early 80s. And there were concerns expressed at that time that that was going to lead to a big decline in safety performance due to the economic pressures that would arise from the expected reductions in road freight rates. Certainly those reductions in road freight rates eventuated. But it's quite clear from all the subsequent literature that looked at this that there was no decline in safety performance coincident with that. So moving on to the question of whether Australian truck drivers are actually badly paid. Obviously we can only hope to get benefits from improving their pay if that is the case. But when we looked at the evidence for this, we found that it was very thin. In fact, a large number of papers on this subject refer to the same consultant study that was undertaken 20 years earlier in 1993. And most other commentary on it was of an anecdotal nature rather than being backed by any actual data. So our approach was to look at the macro level data from the Australian Bureau of Statistics. And what we found was that the average truck driver income across Australia was approximately equal to average economy-wide weekly earnings, which on the face of it seemed not to support the idea that they were badly paid on the whole. We compared that relativity between weekly earnings for truck drivers and the economy as a whole with the same relativity in the US and the UK, and we found that meant Australian truck drivers were a little better off than they were in those two countries. Remember too that I said that there is a centralised wage fixing system. There's an industrial award that applies to all employee truck drivers, which guarantees them relatively high wages. But we also looked at census data and focused on independent contractors and their remuneration. Now that showed that about 20% of them were being paid less than the equivalent award rate for employee truck drivers. Conversely, of course, that meant that 80% of them weren't. So they were earning at or above the award rate. And clearly that would lead you to think that low pay, to the extent that it existed, may have related to poor business skills on the part of a certain proportion of truck drivers, rather than it being a systemic market failure related issue, which is really the underlying rationale for this regulatory intervention. So then we looked at the question of whether other countries had gone down this path, and if so, what had been the result. And we were unable to find any other cases internationally of this being done, of remuneration rates being set in pursuit of a safety objective. We found one state in Australia had adopted a similar approach quite a number of decades ago, and we did two things. We then analysed the safety data for that state and compared it with the data for Australia as a whole, found no difference. And we asked the regulator who was responsible for that system if they could point to any specific evidence of the effectiveness of their system in yielding better safety performance, and they told us that they couldn't. So, to weigh the benefits and costs of this system, and of course this is an ex-ante analysis. At this point, the quasi-judicial tribunal had not yet made a remuneration order. It was moving in that direction, but it was finding it a somewhat challenging task, so it hadn't got there yet. So, taking all of the previous material together, we find there's not a lot of evidence that you could expect significant benefits to arise. We don't see any evidence of better performance in New South Wales, where a similar system-ish is in place. We don't see anyone else undertaking this sort of an endeavour. We didn't see declining safety performance in previous eras when deregulation occurred and prices fell. And the literature gave pretty limited support to the proposition with widely varying conclusions. Conversely, there were a number of indicators that the system was likely to be very costly in practice. Much of the consultation that I undertook yielded comments from industry participants underlining just how complex the industry was, how different the relationships and the payment contracts were, and the fact that it would be necessary to regulate a number of different sectors independently, and so achieving efficient price regulation, determining what would be an optimal, economically efficient level of remuneration was going to be extremely difficult. That was illustrated by the fact that in two states there were guideline rates in place under legislation that provided for disclosure of certain data and various interventions to assist contractor drivers in their negotiation. If you looked at those two sets of guideline rates and a third set that the Transport Workers Union also published, you found that they were extremely variable when you homed in on particular truck combinations. They varied by more than 100% in some cases. So that kind of indicated to us the extent of the challenge that the regulator would have in setting prices at the appropriate level, and indeed the extent of the potential economic distortions that would arise if and when it got it wrong. It was also notable that there was a lack of support at this point for among the purported beneficiaries of the system, who were essentially these independent contractors, who were seen to be the ones who were badly paid and in a poor negotiating position vis-a-vis large freight forwarders. And finally, there was a pretty substantial level of regulatory overlap emerging with the role of the new National Heavy Vehicle Regulator, which derived in significant part from the fact that this tribunal had the power to set remuneration-related conditions. And in its first order in this field, its first exercise of its powers, this was in fact what it had done. It had stood back from the attempt to set rates per se, but it had adopted a very prescriptive approach to a range of contractual matters that it required to be used across the industry. So next, if we're completing an impact analysis, we need to look at alternative policy options. And the focus here, particularly having looked at a range of ITF publications, it became evident that there's a very high level of consensus internationally about what are the fruitful, effective ways of improving heavy vehicle safety. And I list a number of them there. And when we look at the Australian legislative reform process that had been undertaken over the previous probably 15 years since the NTC had been established, we see there's a high level of congruity between the policy agenda that was being followed in Australia and that's being followed internationally. It was also clear that there was a significant program of further reform that was underway in Australia and that was being pursued with, I guess, a renewed vigour by this newly created national heavy vehicle regulator. And again, that program of further reform was quite consistent with what we were seeing as international practice in terms of regulatory reform in this area. So clearly the data on fatalities, injuries, accident involvement suggested that the kind of policy approaches that had been pursued over the last 15 or 20 years and were currently being pursued had substantial benefits. We also looked at a number of indirect indicators, like the percentage of drivers reporting speeding and driving while fatigued, and we saw a similar story. When we looked at previous impact assessments, they generally predicted fairly modest costs for these interventions, and it seemed clear, again from our industry consultations, that they had been largely pretty well accepted. So this was all suggestive of a pretty strong benefit-cost outcome. And the conclusion that a continuation of the existing reform path was likely to be the most effective approach into the future. So continuing the logic of the current suite of policies seemed to be the way to go. Conversely, as I've said, it seemed that there was a pretty weak case for adopting a very strong intervention. Price regulation is almost nowhere pursued, in the Australian economy, as indeed in many of the OECD economies, with the exception, obviously, of areas of natural monopoly, which this is not clearly, and this is clearly not one. To the extent that remuneration is considered to be an issue, there was, of course, a light-handed regulatory option available. This was already in place in the states of Victoria and Western Australia and involved, amongst other things, publishing these guideline rates, which would indicate to truck drivers something about their cost functions and what was likely to be sustainable. And it seemed clear that, given the existence of such systems, in principle, their effectiveness ought to be adopted before there was any question of going down the path of a much stronger intervention, such as actually setting prices. So given all of that, the review concluded that the price-setting power of the Road Safety Remuneration Tribunal should be repealed, and that if some sort of continued intervention were needed, the light-handed models adopted in Western Australia and Victoria should be supplanted by a national approach to achieving those same objectives. We had some fallback recommendations, lest the government not wish to accept those, which would have narrowed the scope of the price regulatory power to contractor drivers, and also that suggested that a memorandum of understanding should be concluded with the National Heavy Vehicle Regulator in order to try and minimise that regulatory overlap and duplication that I identified earlier. So this, I guess, brings us to the political economy issue. The Road Safety Remuneration Act was ultimately abolished. However, that didn't happen until a little over 2 years after my report had been presented to the Minister. There were political reasons, I guess, for the government to delay, which I probably shouldn't go into given the time constraints, but it's worth noting that the legislation always included a review clause, and that the time arose and that was triggered, and a second review was undertaken before my review had actually been released in public. It reached very similar conclusions to mine. Partly probably because I briefed its authors before they began their work. And these reviews were cited ultimately by the government as being in large part the rationale for them determining that they would repeal the Act. But I think it was pretty clear, if you look at the sequence of events, that political factors were ultimately dominant. The government released the two reports together, along with a brief discussion paper, which canvassed the widest possible range of options, from doing nothing to abolishing the Act and the tribunal, and said that it was going to consult for another month. But it didn't turn out like that. In fact, the tribunal had finally got to the point of exercising its price regulatory powers, and they were due to come into effect at very soon after these reports were released. and a number of things happened. There were court actions undertaken by parts of the industry seeking a stay on the application of this order, which were initially unsuccessful. There was an outbreak of major protests and large trucks circling Parliament and so on and so forth. And the net result was that this consultation process was abandoned after about a week. And as a result of all of these things, I think it was pretty clear that the political balance swung in favour of repeal, and that happened very quickly. Within a few weeks of the release of that discussion paper, the Act had been abolished. So we had a report that concluded pretty clearly, using an impact analysis frame of reference, that this had been a very poor legislative approach and that the Act should be repealed. It's important to note, however, that a regulatory impact assessment had been published before that Act had come into effect. That impact assessment found a negative net present value outcome. But clearly you'd have to say it had limited impact because the legislation went ahead anyway. And I'd argue that that was due to a number of quite serious deficiencies in the impact assessment process that was followed. The first, pretty obviously, is that it wasn't integrated with the policy process. If we're adopting best practices here, we need to be using our impact assessment disciplines at the time that we're developing our legislation. Clearly that didn't happen. The policy direction was already very clearly set by 2010 when the government published its discussion paper, if not earlier. And yet an impact assessment wasn't published until late the following year. When it was published, it was deficient in a number of respects. It did acknowledge that there was limited support for this proposition of the link between remuneration and safety in the literature, but it didn't go on to discuss what the implications of this for policy might be. It didn't provide any policy context. It didn't go through any of the work that I just discussed in terms of looking at what the actual trends in safety performance had been over time in Australia, how we compared internationally. None of that was there. So it was impossible to actually grapple with the nature and the extent of the problem. And it also had a very narrow options analysis. There was sufficient commitment, I think, to the idea of undertaking this price regulatory path by this time, that all you saw in this impact assessment were three variants of the rate setting concept rather than any other way of improving safety. You'd have to say that there were problems technically in the impact analysis. At the core of it was a very speculative benefit cost analysis, which assumed that there would be safety benefits. But really, provided no rationale for that assumption. It also assumed that there would be, that the current level of remuneration for drivers was at the economically efficient level. But conversely, when it ultimately argued that there were valid economic grounds for going ahead with this legislation, it did so on the basis of the converse assumption that in fact it was the current level of remuneration was economically inefficient because of imbalances in market power. So the benefit cost analysis really wasn't connected to the conclusion of the impact analysis as a whole. And I'd say in passing too that it essentially focused on transfers rather than economic benefits and costs. So we'd have to say that our quality control systems for impact assessment clearly failed. In that this impact analysis had gone through the process, had been declared as adequate by the impact analysis gatekeeper body. One result of that pretty clearly was that stakeholders were much less able to engage effectively in a consultation process than they would have been if that had been a better document. So finally, what are our lessons? As I said, I think it was clear that we couldn't complete a full benefit cost analysis in this case because of lack of data. But this report, which was essentially an ex ante analysis, nonetheless showed that using the impact analysis framework could provide a lot of useful information for policymakers. if something along these lines had been integrated with the policy process, completed earlier, it might have been quite influential. I made a comment earlier this morning that the cultural change that we need in regulatory authorities in order to embed the benefits of impact assessment is reversible. And indeed, the NTC was the body to which I was making reference. I had previously consulted to them over a number of years. There'd been quite a gap between there and them generating this idea. My experience had been that they were very positive about the impact assessment approach. I had on a couple of key policies been brought into the process at a very early stage, and it was clear that impact assessment was very much part of their thinking and the way in which they got to policy conclusions. But clearly those sort of disciplines were not being followed at the time that they had gone down this path. It's clear that this was a political issue from the beginning, and once the microphone's turned off I might say more about that. But the point is that impact assessment is about making politically driven choices that are rational from a politician's viewpoint but not so rational from the viewpoint of society as a whole harder to make. And so it's particularly important that good quality impact assessment is done in that sort of politically driven environment. And I'll just leave you with a favourite quote from the OECD, the point of which is that impact assessment largely is of benefit because of the frame of reference, because of the way that it causes us to think about policy issues, to be systematic and comparative. That's the fundamental element rather than the precision of the calculations that we're able to undertake. Thank you.